It is my privilege to introduce our esteemed guest speaker for today, CS Jasmeen Kaur ma'am, who will be sharing her valuable insights with us on secretarial standards. Jasmeen ma'am is a seasoned professional with an illustrious career spanning nearly 20 years in the field of corporate law, legal matters, and secretarial standards. She is a fellow member of Institute of Company Secretaries of India and also a proprietor of Messrs. JK and Associates, a well-respected firm of company secretaries with over 18 years of experience in the field. In addition to her professional achievements, Jasmeen ma'am has contributed to the community as a member of Women Empowerment Committee of NIRC in both 2020 and 22. Her extensive experience and leadership in corporate law make her an excellent speaker, and we are extremely fortunate to have her with us today. This guest lecture is a part of series of guest lectures that we have planned for this year, and we are confident that today's session will be enriching and insightful experience for all of us. Please.
Thank you so much for the introduction. And it's my good evening, everyone, and it's my pleasure to be here with you all. And I really hope, as well mentioned, that this session ends up as enlightful and fruition for everybody. So, as you all know, that today the session is all about the Secretarial Standard 1. And Secretarial, we understand as a legal professional that how important it is for the board members to take the decision, and because those decision is the baseline for the running of the company. So for a good governed company, it is very much necessary to have an effective board decision being taken with the complete legality, with the complete transparency, and within the prescribed norms. And secretarial standards provide us the guidance to that those norms. So without going into the general thing, I just wanted to let you know that this, before the secretarial standard were there was, the law was there, but there was no uniformity in the working style of the companies. Every company was following the law in their own comfort zone and as per their own requirements, which was creating a lot of litigations also among the management. So these secretarial standard, I very well always say that this is kind of a bible for the company. It provides so much of information that if you go through this secretarial standard along with reading the guidance note, it gives you a complete picture of how to conduct the board meeting. Because having a board meeting or passing the resolution is not sufficient if it is not in compliance with the provision which are required to be complied with. So it's a small disclaimer. So we are trying to share this knowledge, but this knowledge should not be construed as a legal opinion. And one more very important thing I need to mention, that these secretarial standards of India, like this is a made in India thing. And this has been adopted by few of the countries as it is. Like Malaysian government wrote to an Indian government to grant them the permission to adopt this secretarial standard, detailed secretarial standard for their country too. And way back, I heard somewhere way back in 2007, before the secretarial standard came into the picture, which was in 2015. The current secretarial standard were introduced in 2015, 1st of July. But before they were being made mandatory, those were adopted by the UK institute on the basis of the draft secretarial standard. So from this you can understand how important and detailed thing this is. So coming to secretarial, it's a formulated secretary for the board meeting. As you know, we have SS-1 for the board meeting and SS-2 for the general meeting. And because it's such a detailed topic that we are touching the SS-1 only in this session. So secretary, what is the basic difference in secretarial standard and guidance note? See, basically secretarial standard is a legal thing. It provides a legal procedure to be followed. Whereas guidance note is kind of a guidance which shows us the path, how this legal framework to be executed in the best possible manner. So because secretarial standard is a legal thing, it need to, in case of any amendment required or changes required, needs a ministry approval, as the in case of acts also. Whereas in if any kind of a change or detailed elaboration required in the guidance note, it can be done by the institute through the council board of the Institute of Company Secretary of India. So the provision we will be touching, the secretarial standard mostly covered in consensus with the section like 173, 174, 175, 118. These we have mentioned the section for your in case in future cases. If you get any kind of a query from the clients, you can always refer to these sections also along with the secretarial standards. Can we go to the next slide? Very important thing, secretarial standards applicability. So friends, the secretarial standard, as we know, is applicable on all the companies, whether it's a private company, it's a listed company, unlisted public company, or a small company. Even it's applicable to the companies which are governed by the special act, such as like insurance companies, banking companies, which have a special act to run. But these secretarial standards are applicable to those companies also. And in case the company is having some statutory committees which are mandatory for the company to have those committees, especially applicable to like so listed or unlisted, because there are hardly any statutory committee for the private companies. So in those cases also are applicable. Next slide. Whereas there is an exception where it is not applicable to non-profitable companies. Earlier we used to say section 25 in the previous act. So this is section 8 company which are running for a non-profit reason, which you say NGOs also. On these companies the secretarial standard is not applicable, but there is an exception. But if there is a non-compliance of filing statements or annual return with the ROC, then in that situation, because the company is in default, then the secretarial standard become applicable. Then OPC, one person companies, it is not applicable on the one person company. Then another two exceptions are IFSCs, public companies, and IFSC. IFSC is International Financial Service Centers, which you know like is very upcoming thing these days. So on public and private IFSCs, this secretarial standard is not applicable. Next. Convening a meeting, as we say that the foremost thing for a company to be run in a more good governed manner, that the board meeting of the company should be conducted with the complete transparency, with legality, and in the prescribed norms. So this whole slides provide us how to convene a board meeting. Here, who can conduct a board meeting? Who can call for the board meeting? Is the director can summon a meeting, including an independent. ID is independent director can summon a meeting. So other than director and independent director, nobody can call a board meeting. Even a company secretary cannot call a board meeting, even if there is, if he or she knows that there is requirement, like there's a gap of 120 days beyond which you cannot go, etc., etc. So there is a requirement for a board meeting. He can suggest to the directors, he can convene this message to the chairperson, take their approval to hold meeting, but cannot directly hold a board meeting. So director has to summon, or an independent director can summon, and CS company secretary. And where there is no company secretary, board can authorize some one particular person as who can take the charge for conducting of the board meeting. This company secretary would take a consult with the chairperson. In case company have a chairperson, managing director, whole-time director, the company secretary will consult with the chairperson, MD, whole-time director, unless articles provide for some stringent provision. Friends, here we have to understand whatever will be reading in the secretarial standard thing is the basic norm which need to be followed. whereas company can have a stringent provisions as per the article of association. So it's always suggested that in case you are checking or conducting a board meeting, or they are in the compliance, it should be in consensus with the law, in consensus with the secretarial standard, and in consensus with the articles of the company too. Then requisition are the procedural thing that the requisition should be in writing, and in case if it's not in writing, then company secretary should put this in writing and bring it to the chairperson and all those points. Another important thing is day, time, place, mode, serial number of the meeting. So this serial number thing is very important, very, very much importance, because earlier, what was the thing? There was no serial number requirement. So in case at the end of the year, when you're closing your finances, or at the time when the company secretary is preparing your annual records, they could find some discrepancy. And what was the usual practice? To have an additional board meeting added in the existing board meeting which were being conducted. But because now it should be serial numbered, can be on the basis of calendar year, on the basis of financial year, or if company is a very good governed company, it could follow a number in continuation from the inception, from the incorporation also. Serial number, important point, serial number of the original and the adjourned meeting should be same. Meeting may be convened at any time, any place. For the board meeting, there is no restriction that it cannot be held on a holiday or a national holiday. But as a good governance, because board meeting can be conducted with the by the board members with the help of assistance of the office staff and company secretary and all other invitees involved. So it is, as a good governance, it is always advisable to have it on the day during the working hour. Meeting has to start during the working hour. It could stretch beyond the working hour too. So venue for the meeting, where can you hold the board meeting? As per the new provisions, the board meeting of the company can be held anywhere in India, in abroad. There is no restriction. Then again, I would say you need to cross check with the article if there is any restriction that board meeting has to be in the state where the registered office of the company, or the city where the registered, or in India only, or etc. You need to cross check with your articles. Then notice of the meeting should clearly mention the venue. What would be the venue in case the board meeting is conducted through a VC mode, like electronic mode? Because we have an option to hold meeting physically also, and in the electronic mode. Especially after this COVID thing, this electronic mode has of importance, and everybody is finding it very convenient to have a board meeting sitting at their own convenient place. So in that situation where the recording is happening of the meeting is considered as a, and when we say the recording is happening, then there should be either a company secretary should be present or the chairperson should be present there. So in another way we can say the venue of the meeting could be address where the company secretary or chairperson of the company is attending the meeting, where the recording is also being done. And recording should be always safeguarded, and as per the law we require to need this recording to be in the safe custody till the audit of the company is done. Beyond that, if you want to keep this record, the company can maintain optionally, but there is no legal requirement. It is to be only up till the audit of the company is done. Company secretary, I already mentioned. Next page. As we said, it can be in a physical and electronic mode both. Then notice of the meeting points which I've mentioned, that notice of the meeting with regard to service of the notice and agenda of the meeting, and notice shall be issued by. So service, speed post, registered post, FSML, email, or any other electronic mode. Which address which is registered with the company, or the email the company, or until and unless director has given any specific specification that I want my board meeting notice to be sent to my PA address, like personal executive, rather than coming to director, because director knows he'll be traveling all the year round. So instead of, he doesn't want to miss out on the notice, so he gives assistant's email ID or address where the notice to be given. So in that situation, it is to be in that specific address which has been given by the director. It should be given to original. So like, this concept of alternate director has really lost its relevance now, because meeting, it was because for the foreign traveling director, this option, this concept of alternate director was being introduced. Like, in case the director is not in the country, the company can appoint an alternate director in his absence or her absence. Whereas now, because board meeting could be conducted electronic form, the alternate director point has really lost its importance. Notice attended by. Who can issue the notice? Company secretary. He cannot call the meeting. It is called by, summoned by director, as we understood earlier, by the director or independent director. But he'll always be assisting in conduct of the board meeting. So company secretary or any person authorized by the board issue the notice. The directors who desire participate in electronic mode, they can either confirm to the board at the beginning of the calendar year, or at the time of the meeting they can choose the option that they want to attend the meeting physically or electronic way. Then notice should be given at least 7 days before the, here the 7 days, we are not using the clear days. So the meeting is not calculated from the notice day is calculated. Had it been a clear 7 days, then we exclude the date of the meeting and the date of the notice, both the things. But because it doesn't mention about the 7 clear days, so it'll be date of the notice and then additional 6 days. So that ways. Next page. Likewise, adjourn notice for the adjourned meeting. The notice for the including those who did not attend the meeting, the notice of the adjourned meeting again to be given to all the directors, even to the directors who have not attended the previous board meeting. And in case of adjournment of board meeting due to quorum is not present, the meeting has to be adjourned to the next week, the same day, same time, same venue, same. But and in that case also, you need to give the 7 days or a shorter period of notice. You can give the notice in the meeting itself. The chairman, unless dissented or objected by majority of director present in the meeting, quorum is present. So chairman has an authority to adjourn the meeting, but he could only do until and unless the majority of director dissent to it. So, until and unless directors are not dissenting, chairman has an authority to adjourn the meeting for any other reason, because for the lack of quorum, the meeting automatically get adjourned. But for any other reason, chairman has a power to adjourn the meeting. Very important things, proofs. How we need to maintain the records, and this, I think, these things, as a legal professional, you come across the cases where you need to know that these records should have been maintained by the company for this particular time. So this nuance for secretarial standards plays a very important role in such situation, that the record of proof of sending and delivery of notice should be, and along with the HR, should be maintained for not less than 3 years. Again, we I would say, in case articles provide for the stringent provision, it is to be for that longer period. Otherwise, for at least for 3 years, the law 3 years. Consequences. This is very important. What is marked in the red color is with regard to the legal provisions, where the whole situation can turn. In case, like, everything is in record, like minutes are there, but there's no record of sending of the draft of the meeting, no notice of the meeting. So any material irregularity in the notice can affect the validity of the meeting itself and the decision taken thereat. So the meeting itself become invalid in case the notice has not been given properly, notice has not been given to all the directors, etc. All these points, whatever with regard to notice, the proper clear days, proper the gap between the notice is not proper as per the law. All these things invalidate the meeting itself. Whereas notice of the meeting is not sent to all the director, resolution passed at the meeting also become invalid, because meeting get invalid, the resolution passed in the meeting also get irrelevant. Prior intimation of the board meeting given to stock exchange. These provisions I have given for your references only, where because for the companies whose shares are listed on the recognized stock exchanges have an additional requirements other than secretarial standard, where there are certain items which need at least 2 working days prior notice to be given, whereas for certain items like financial results and etc., at least 5 clear days notice is to be given to the stock exchange. And there are certain items which need at least 11 working days. Working days we exclude Saturdays and Sundays. The holidays we exclude, or in case there is a national holiday in between, we exclude those. Next, please. Again, this is with regard to the listed company only, like in case of unpublished price sensitive information. The directors could decide that this information is price sensitive and they cannot give a 7 days agenda or 7 days notice in advance. So they can have a general consent at the starting of the year, or they can take a particular consent for that particular meeting, that this item can be is sensitive, price sensitive information, so a shorter period of notice will be given. And in case the company is having an independent director, the approval and ratification of that independent director is very much required. In case he doesn't give a consent to it, then the 7 days notice is very much required to be given, even for that price sensitive information. Then supplementary notes. What are the supplementary notes? Like notice you have given, agenda you have given, but because there is a gap of 7 days and some development happened with regard to the item which you have sent for the resolution, like there is some approval for the project, you have given a costing, you are taking approval for the cost of the project, but in between there is a price hike or something which need to be upgraded to the board, or there's some other important information which need to be shared at the later stage. So those can be sent through a supplementary note. Here also the majority of directors present the meeting and independent directors permission is required to accept those supplementary notes which have come beyond the agenda. The notes to set out the detailed points for discussion. This is also elaboration you can read, and draft resolution should also be given along with the notice, because if we need to pass one very important thing, there are certain instances like in case of opening of a bank account, or some tender need to be filled. So immediately after the board meeting, you need to give a certified copy of the resolution. So certified copy of the resolution can be given immediately after the board meeting, whereas extracts of the minutes of the meeting can only be given, a certified copy of extract of the minutes can only be given once the minutes has been entered. So that for these practical reasons, the resolution, draft resolution should always be there, so that resolution can be approved in the meeting, and in case situation arises can be given immediately after the meeting. Next. Permission of chairman, any item not included in agenda. As if you any of you have gone through the agenda of the meeting of the board of director, the last slide usually says, after mentioning all the item which need to be taken up in the board meeting, the last item says any other matter with the approval of the chair, or you can say approval of the chairman. So chairman has an authority, power to allow to take up any other important matter which was earlier not mentioned in the agenda, but there is a extra compliance required, because to avoid any kind of a manipulation, like agenda is not include having this particular item mentioned in the notice which is given to all the directors, and knowing the fact that this particular director could not attend the meeting because he has already taken a leave of absence in advance, and then now in the meeting you decide to take up another matter of say investment or giving loan or etc, which the board has an idea that he could have resisted to. So because of to avoid all these manipulations and falsifications, so it is there is a special permission required that such decision which the items which were being not mentioned in the agenda taken in the meeting should be rectified by the majority of directors of the company, not the majority of director present in the board, present during the meeting. It is to be the majority of director the board is having. So, in case there is a board of seven directors, and quorum says three directors, and three directors are present, and majority of three is two. So, because you have added an agenda item which is not already mentioned, so that particular item is not it will not be approved by the two director. It will be approved by the majority of seven director, which is four. Transact urgent business. Again, the notice, as we know, that 7 days clear notice to be given. Somebody is saying something because I cannot hear. I think Abhishek. I could hear some voice. Is it with regard to me? Because it's not very clear.
I think, ma'am, he is leaving his line on. Let me ask him.
Okay. Yeah. Urgent matters, like in situation of urgent matter, you shorter period notice also, and this because board decides something, especially in a closely held companies, like two directors are sitting across the table and they decide we have to be in a particular manner. So they show the notice at a shorter period of time, take the meeting in 1 hour's time. So in that situation, or in case the company is having an independent director, then that approval of rectification by the independent director is required. And in case the company does not have an independent director, the decision shall be final on rectification by majority. Same as we discussed for the agenda item which was beyond taken up in the meeting only, you need the rectification by the majority of directors. Same way for the shorter notice, you need a rectification by the majority of director, and if there is an independent director, by the independent director also. Next. Disclosure of outcome of the board meeting. This is with regard to the equity listed companies, like within how much, like 30 minutes, you need to disclose the result of the meeting with the stock exchange. And I think you can go through all these because every item a framework like financial results in case, or you are declaring the dividend to the company. So the decision of the board has to be given to the stock exchange immediately after the close of the meeting, that is within the 30 minutes of time. Next. Frequency of the board meeting, as we all know that there has to be at least four board meeting by the by other than the small companies, other than startup companies, and the board meeting has the normal other than small and startup companies, OPCs. Rest other companies need to have at least four board meetings with the maximum gap of 120 days. The gap between the two board meetings should not exceed 120 days. Earlier, there was a requirement to have a one board meeting in each quarter, but now it has been dispensed with. So the only requirement is the gap between the two board meetings should not be 120 days. Here, in case of an adjourned meeting, like meeting was held on this particular day, and the adjourn meeting happened to be on a 7 days after the previous meeting, or after 15 days, whatever, whenever you close the adjourn meeting, the gap is to be calculated from the original meeting to next original meeting. The adjourn gap of adjourn meeting will not be calculated. Like 1st of January, you are holding the meeting, and then 1st of April, you are conducting, 1st of May, you are conducting the second meeting. So there is a gap of more than 120 days. It should not be more than 120 days. First meeting to be held within 30 days of incorporation. Other than that, small company OPC and dormant company. Which are the dormant company? Which are non-functional company. The companies having a litigation, so for that reason they cannot close the company, but there is no business. So normally the company file for the dormant status so that they can have a compliances to be complied with. So those companies also need to have a full board meeting. For the small company OPC and dormant, OPC only require the meeting in case there is more than one director, because OPC can run by a one director also. So in case OPC having more than one director, it need to have a meeting. Like the small companies, they need to have a two board meeting with minimum gap of 30 days. In case of no other companies, it is maximum gap of 120 days. In this case, it is minimum of 90 days. So like one board meeting you are holding on one particular day, and another meeting is on after 25 days. So though it says minimum two board meeting required, you are complying with one part. Two board meeting has already happened, but because there is no gap of minimum gap of 90 days, so from the original date of the first board meeting to the 90 days after the completion of 90 days, you need to hold another board meeting in half of a calendar gap. So one meeting has to be in from January to June, and next meeting has to be between the July and December. Meeting of committee. There is no particular requirement that how many committee meeting need to be happen. This can be stipulated at the time by the board only at the time of formation of the committees, or articles can provide, or otherwise if not mentioned, then as and when required. But there has to be one, like in case of audit committees, the financial, there are certain items which can be dealt with by the audit committee only, like in case of declaration of dividend, approval of financial, related party transaction, everything. So those items, whenever those items approval are required, you need to hold the committee meeting. Meeting of independent director, at least one independent director meeting in a one financial year is very much required. They can meet more number of times, but in the independent director meeting, there will not be any non-independent director present until and unless they approve to it for any particular purpose. Company secretary can always assist them in holding the meeting, convening the meeting, but he cannot be the part of the meeting unless and until independent director wants that. Next.
Excuse me, ma'am.
Yeah, please.
Ma'am, are we using the terms calendar year and financial year interchangeably over here?
Yes, here I have mentioned financial year, and in previously in case of OPC, small company, dormant company, I use the word calendar year. It is specifically mentioned. Where it's calendar year, it's from January to December, and where it's financial year, it'll be from April to March.
Okay, so they're not interchangeable terms. They are
No, no, they are
different.
not. They are not interchangeable.
Okay, thank you.
Yeah. Next, please. Quorum. The quorum of the meeting, minimum number of director which need to be present to form a quorum is 1/3 of the total strength, or two director, whichever is higher. And in the situation where 1/3 is coming as a fraction, the fraction has to be next number. Like in case of 7 members, if 1/3 is coming to 2 point something, so it'll be 3. So it'll not be 2 point something, it'll not be 2, it'll be 3. So next number. Again, articles can provide stringent provision. Articles can provide the minimum of out of 7, minimum of 4 members has directors have to be present. It shall be present throughout the meeting. The quorum has to be throughout the meeting. It's not that at the starting of the meeting you had a quorum and then you are continuing the meeting without the quorum. There will be only one or two directors. You cannot continue the meeting without the quorum at any time during the meeting. Articles can provide the higher quorum. Interested directors shall not be counted for quorum. Very specifically mentioned, interested directors cannot be counted for the quorum purposes. The in the next few slides you'll find a table which is very useful. I think that is the best picture. It'll clear your picture very perfectly, that where the quorum, where the interested actors will be counted and where it cannot be counted at all. Directors present through VC and OVM counted for the quorum. Now, because the meeting can be conducted through electronic mode is also allowed. So the quorum present to electronic mode is also counted for quorum purpose. Alternate directors treated as interested, not entitled to vote if he himself. As I said, alternate directors, I actually lost the important, but still because law mentions, so I'll clear. In case alternate director himself is interested, will not be counted for quorum. Whereas in case he is on the place of original director and original director is an interested director, then in that situation, alternate director will be counted for the quorum. Exemptions available to private companies. There is an exemption for this interested director quorum. The interested director can participate, can vote, and be counted as quorum after disclosure of interest. Like there is a one disclosure of interest to be given by all the directors at the starting of the financial year in MBP1. There is a form MBP1 where all the directors have to give the disclosure of their interest in another companies, firms, partnership firms, body corporates, etc. But in case there'll be any change in their interest during the year, again this fresh MBP1 form need to be given. And after in the meeting mentioning that I am interested in this particular item, extra disclosure during the meeting itself, you can be in private companies case, the interested director can participate and vote and can be counted for quorum also. For the purpose of body corporate, like I think for this is the definition of interest. Like in case of a body corporate, if director alone or with along with the other director of the company holding more than 2% of the shares, paid up capital, PSC is the paid up share capital of that body corporate, he is counted as an interested. And in other cases like firms and entity, if the director himself or herself is a partner or owner or a member of the firm or the company, then in that case he'll be counted as an interested director. Next, please. And this interested directors concept is also very important from a legal point of view, because most of the time these kind of litigation come across, especially in a closely held companies where they are running 4 5 companies with the same board of directors and etc. So these kind of issues do come across, come during when you are dealing with the legal matter. Disclosure of interested directors, as I said, it is to be given by in first board meeting, which in case of a new director, he has to give it in the first board meeting in which he participate as a director. And then interested director to disclose his concern at the board meeting where the contract arrangement is discussed. Though he has given a general disclosure about his interest in other companies, he has to particularly mention his interest in that particular meeting where he is present in the quorum, and this item, the interested item, is being taken up for the approval. If all the directors are interested, then the matter will go to general meeting, because if all the whole quorum is interested, like both the directors, there are two directors only and both the directors are the interested party, then it'll go to for the approval of general meeting. Even if the members of the company are also the directors of the company, like it's a closely held company of two brothers, and the same brothers are holding 50-50% shares, even then, because the quorum is interested, so board meeting is not a valid meeting. In that case, the approval of the member in the shareholders meeting by the same person is required. In case of related party transaction, interested director can neither be present at the meeting nor vote. There's a difference in related party transaction and interested items. Related party transactions covered under section 188. 188 provide few items which are covered in related party transaction, like sale and purchase of goods and services, lease agreements, etc. There are 4-5 items which are mentioned. Those items are covered in related party. For related party items, the quorum interested director cannot be counted as quorum or not allowed to vote, etc. Whereas for other than the items which are related party items, but in which the director is interested, he could participate after disclosing his interest. As I said, interested directors shall not be present at the meeting nor vote on such item in case of related party. So, in case of related party transaction, in case the meeting is going through electronic mode, he take a seat back, he exit the meeting, and then rejoin again after that agenda item is taken up by the rest of the non-interested directors. Participation in quorum through e-mode. Directors should be counted for the purpose of recounting quorum. So again, electronic mode, in case meeting is being attended by the directors in electronic mode, they'll form the quorum. If interested director exceed 2/3 of the total strength, the remaining director present, not less than 2 shall be quorum. There's one more provision, like if quorum of the meeting is suppose coming out as 3 directors, but the total number of interested directors are as much that only 2 directors are non-interested, then in that situation 2 directors shall form a quorum. But if it will be less than 2, like a single person only who is not interested but rest other are interested, then in that situation you need to go to general, take the approval of the members. Next please. Consequences of meeting where quorum is not present. In case quorum is not present, as I discussed earlier also, the meeting get adjourned to the next week, the same date, same time, same place. And in case that day falls as a national holiday, then to next succeeding day, which is not a national holiday. If number of director reduce below minimum, like suppose article says the company should have minimum of 4 directors or 3 directors. So, in case due to the demise or resignation of one of the director, the board falls short of the minimum number of directors required by the company. Say there's only one director now. So, in that situation, that one director can only hold the general meeting, call for the general meeting for the appointment of the new directors to uh, bring that board to the level of minimum number of directors required by the company. And no other activity can be done by that director beyond who is fallen beyond the board, but no other activity can be done by the board which is fallen below the minimum number of director required by the company. The board that consists of director less than number of minimum fixed cannot exercise the function other than calling the general meeting. They can only call for the general meeting to to appoint the new director. Next, please. Attendance at the meeting. This is also very important, as I've come across many cases also where minutes are there. Company present those minutes as a proof that the meeting was held and the minutes were noted down and minutes were signed by the chairperson. But where is the proof that the directors attended the meeting? So in those litigation cases, this attendance register plays a very important role. So attendance register need to be signed by by the board, by the invitees who can be invitee, like company secretary who is conducting the meeting, assisting in the meeting, and any other company secretary will be counted as an attendant, whereas invitees could be like in case there is a approval for internal report, auditor's report, so internal auditor will be an invitee. there is an approval for a bank loan. So bank person who is there to bring out the terms and conditions for the loan will be an invitee. So any third party will be an invitee other than directors and the company secretary. Even the KMP, like CFO attending the meeting, could attend meeting as an invitee only. So the it should contain the name. The attendance should have the name and signatures of the directors, company secretaries, invitees, and the mode they have present. In case of electronic meeting held through electronic mode, the person cannot sign the attendance register physically. In that situation, he gives his approval, consent to the chairperson or to any other director to sign on his her behalf, mentioning that he is attending the meeting through electronic mode and particular place, like he is attending through Singapore, he is attending through some other place in India like Gujarat. So mentioning all those details, the chairperson of the meeting or the any other director who has been authorized by the board can sign on behalf of the other directors who are attending the meeting through electronic mode. Uh, in the absence of the copy of notice convening board meeting and the logbook, here logbook is the attendance register meant to record signatures of the director attending the meeting and any other proof, a meeting cannot be accepted to be held. You can, anybody can deny that. In case if company, the onus is on the company, the board, to prove that this meeting being held. So minutes book is not the only proof. It is to be supported by all other records also, like registers to be maintained, like proof of notice being given, proof of draft of the draft minute about the minutes will be understanding in the later of this slides. But like proof of draft of minutes being given, everything has to be kept in record to be meeting to be a valid meeting. The simple minutes of the meeting cannot uh, justify that this meeting was held.
Excuse me, ma'am.
Yeah, please.
So, ma'am, e-mode attendance has to be authenticated by chairman or CS. So this authentication has to be either through electronic signature or digital signature. How it will happen?
No, the director who is attending the meeting through electronic mode will give his approval during the meeting through electronic mode only, verbally. Give his approval that I am attending this meeting through an electronic mode. I give authorized chairperson of the meeting to sign on my behalf, or the other director authorized to sign on my behalf. To be more cautious, in case if you want to add, company want to make it more stringent and more transparent, company can ask for that particular director to drop an email after the closure of the meeting, like I have authorized the chairperson of the meeting or the other director of the meeting to sign on my behalf. But this is not the requirement as per the secretarial standard. Secretarial standard only says he or she could authorize the chairperson or some other director to sign on his or behalf.
So authentication primarily means the consent given that you will
Yes,
sign on my behalf, right?
yes, of
Okay,
course.
okay.
Next, please. Here also case study, absence of any documentary proof to show that notice of the meeting was sent to the petitioner and that they were present in the meeting only by inclusion of their name in the minutes, which was signed by the respondent chairman, and no attendance register could be presented. To substantiate these facts, it may be inferred that the meeting was sham and fabricated. So this case law is very clearly mentioned about the thing I mentioned just now, that the minutes is not the only proof; it has to be other supporting documents as well. Roll call is a procedural thing in the electronic meeting where the director need to mention the name, his name and the location he is participating the meeting, and that whether he has received the agenda and the notice well on time, and he has to mention that there is no unauthorized person present in the meeting, because when you are attending the meeting board meeting is usually a very confidential thing for company. So whenever the conference, this board meeting is happening, only the only the person with the approval could only attend, like invitees or attendees, like company secretary. Those limited people can have an access to the board meeting. But when the meeting is being conducted through an electronic mode, to comply with this requirement, we make the director responsible by mentioning that there is no unauthorized person present from where I'm attending this meeting to. Again, I'll say, to make it more stringent, like articles could say that he could only attend the meeting through some particular place, even if it's from an electronic mode, so that they can have an access that nobody else is attending the meeting. These are the additional restrictions a company can add through its articles. Other important point, maintenance. It shall be maintained at attendance register has to be maintained at the registered office, and in case such other place, if you the board need to take it to some other place, that it is to be approved by the board. Even if the board need to take the attendance register to the courtroom to be presented as a proof, as a document, so then in that case also a board approval is required. Next, please.
Excuse me, ma'am.
Yeah, please.
So, ma'am, registered office. So, I've seen like in a lot of companies, they are having corporate office and head offices. So, I
Right.
understand registered office is the requirement under law. So,
Yeah.
if it is being maintained simultaneously at the other offices, so it could be like interchangeable, like we can just maintain it at the corporate office, or it has to be
Hmm.
together with the registered office. The
Registered office
maintenance.
is the legal term which by the law. There is the corporate offices and head office of the company is the fancy words, and a branch offices of the company it could be. But registered office is the address which is on record at the MCA, which you have given to the Ministry of Corporate Affairs, that this is registered, where the department could communicate with the company. So that is the registered office of the company. You can mention that it as a corporate office also, but in case company is having a separate corporate office, separate head office, then in that situation, the register has to be maintained at the registered office only. But in case if you want to maintain some other place also, you need an approval of the board.
Yeah, ma'am,
And then,
because of
sorry.
the convenience, I think companies are making registered office sometimes just to collect the documents as required in the law, and
Right.
they are having a corporate office at a different location, probably more fancy location in terms of their
Yeah,
business.
sometimes they have a registered office where they could get a tax benefit, or surrounding is appropriate for the requirement of the functioning nature of active business activity of the company. Whereas the corporate offices are at the more decent places, like which is a more elegant place to hold the meetings and where the directors could come.
Okay, ma'am. Thank you.
Yeah. uh, this topic, inspection. Inspector can inspect the register, attendance register. Um, the directors of the company, this attendance register, as we are talking about the attendance register of the directors, so the directors have an access to inspect the attendance register, whereas he can entitled to inspect the register of the meeting held during the period of his director, even after he ceased to be a director. In case some litigation come on him where he need to prove that I have attended this meeting, just one second, I've attended this meeting, so, and he need to prove that, give that document in the courtroom, he can ask for the copy of that attendance register during the period he was the director of the company. So for his tenure, he can ask for the to inspect the attendance register and the copy of it both. Then who else can inspect the attendance registers? Practicing company secretary for their annual filing purposes and all. Secretarial auditor, statutory auditor can also inspect. The officer of regulatory authority, like regional director, ROC, etc. These departments can also ask for the copy of attendance register. Then the member of company are not entitled to inspect the register. It specifically says, because this is the register of attendance of the director, so members have no authority until and unless articles provide. Again, so articles can be more stringent. If articles are providing to give this liberty to their members, so they can make their provision more stringent. Then it should be preserved for at least 8 financial years. Very, very important that it should be placed from, and how this 8 financial year time to be calculated is from the last entry made when you are destroying with the approval of board. When the last entry is made, from that date, you count the 8 financial years, and then you can destroy it after 8 years only with the approval of board. It cannot be destroyed otherwise. Then vacation of leave of absence. These are few other points with regard to director. The director can ask for leave of absence. Vacation of office of director, this is very important from a legal point of view. I'll say, in case a director is not attending a meeting for 12 months, then in that case the director vacate the office, and not even the board approval of the board is required to vacate his office. Like, he automatically vacate his office on the completion of 12 month. And this completion of 12 month, how we calculate from the next board meeting prior to which he attended the board meeting. I would read the line, it'll make 12 months. The counting should be commenced from the date of the first board meeting held immediately after the meeting which director concerned last attended. Suppose his last attended meeting was on 30th of June, and after that the next meeting was on 1st of October or 1st of August. So you will calculate 12 months time from 1st of August, not from 30th of June. And the board resolution need not to be passed to show that the office of director vacated. You can immediately file the DR12. There is a form DR12 for the resignation, for the removal of cessation of directorship, can be immediately filed after completion of 12 years. The attendance register should be in the custody of company secretary. Next.
Excuse me, ma'am.
Yeah.
Ma'am, this preservation time, basically to retain the data of the board meetings, right?
Yes.
Is 8 years. How they have come to that number 8 in terms of
This is given by
time?
the law. Secretarial standard is a legal procedure. Secretarial standard is not the procedural part. So it's a legal requirement. Whatever mentioned in the guidance note is for the ease to understand the law, whereas secretarial, whatever mentioned in the secretarial standard is a legal requirement, and secretarial standard mention that it is to be maintained for 8 years.
So,
And
ma'am,
that period of, okay,
yeah, yeah, my question is like,
how to calculate, from which date to calculate 8 years?
no, so I got that. In terms of retention of data, basically, how we are retaining data in, say, different organization, like, say, if you talk about e-commerce, there we retain data from the date from which the customer has bought the product, and then 3 years. So there's a limitation under law that within 3 years he can bring any action in the court of law. So here
Right.
also this is a sort of like within 8 years, any kind of inquiry or investigation or penalties or fine can be retrospectively put on the company. That's why they have bring in that 8 year time period. That's just trying to understand
In
the.
case, yeah, definitely. In case any case come crop up during the this period of 8 year with regard to falsification, fraud, or manipulation or anything, this record can be referred back to. And for this
Yeah,
reason only, and minutes, you'll get to know that minute is a permanent record.
yeah,
It's a permanent record. Company cannot destroy the minutes of the company till the end of the time, like till the time, because company is a perpetual succession. It doesn't die. So till the
right,
time company wind off, you need to maintain. It doesn't mean that the limitation period of 3 years is not applicable.
right.
uh, both the things are different. Like, limitation period 3 years is a different thing, but
Yeah.
when inspection, frauds, investigation by the department, or some legal thing comes where you need to refer to the records, and if company is not maintaining record which is required to be maintained for 8 years, is a non-compliance. It has nothing to do with the limitation period. Limitation period, I think, is 3 years, as you said, na, it's 3 years only.
So ma'am, because see, so there is we are doing a lot of compliances in data protection as well, and therein we have clients with us which has certain set of data which needs to be retained. So in
Okay.
company law, it is very specifically given, but in couple of laws, it's not given. Like in Income Tax Act, it was earlier 12 years. Now I think it has become 7 or 8 years for
eight,
retention of data,
eight
because
years.
even if it is in a digital form, it is tons of terabytes of data is there. So there has to be some limitation within which you need to remove it so that you can have a proper space, digital space to store it. So that is why
Right.
I'm asking that.
Okay, okay. Yeah, 8-year time period is required as per the secretarial standard for the good governance. And this is not the good governance, it is the compulsory requirement. It's a legal requirement. If company is not maintaining, it's a non-compliance on the part of the company.
Okay, yeah, thank you, ma'am.
Yeah. I hope I've made your point clear.
Indeed, indeed, yeah.
Okay. Chairman, appointment of a chairman. Chairman of the company would be the chairman of the either the chairman of the company. If company is having a position given to somebody, some of the director as a chairperson, that person will be the chairperson for the board meeting. And in case that chairperson of the company is not available, then the existing director can choose one among them as a chairperson for that meeting. And also if elected, the chairperson of the company is not present within 15 minutes of the time given for the meeting, in that situation also they can appoint somebody else as a chairperson. Managing director, CEO as a chairperson. Can managing director or CEO play the additional role as a chairperson? No, because the basic intention behind not giving this same two position to the same person is for the reason that non-executive director can be a chairperson, because executive director is already involved in the day-to-day working. Managing director, CEO is already involved in the day-to-day functioning of the company, so they cannot be pressured with the additional position. Whereas there are certain exceptions which mentioned in the PPT, you can refer to, like there's a threshold limit on capital and turnover, and in case company having a different CEO for the different activity, in that situation it can be coupled. Next, please. Duty chairperson plays a very important role. He the authority, like chairperson who only files the minutes. He is the charge that which additional item can be taken up in the meeting, approval of the majority directors. He is the final person who decides that what needs to be mentioned in the minute. If you find this is something which is defamatory or which is not relevant or irrelevant, we can make sure that this cannot be the part of the minutes, because otherwise minute is the transcription of whatever happened in the meeting. But he could take the call that this particular part should not mention in the minutes, for the reason that this is not a relevant part. If the board has not appointed, the company may elect the chairperson. um, I can go in detail only in case if it is. I think this chairperson right to cast a vote is an important thing. All other things are little procedural thing which are not very from a legal point of view. So you can go through. I'm highlighting on this chairperson right on casting vote. So in case there is a equal vote, two are in the affirmation and two are against the decision. So in that situation, the chairperson has a casting vote, which is the second vote. But at the same time, again, in case articles provide that chairperson will not be having a casting vote, then in that situation, he won't. Next, please. I think something popped up. Okay, please. This is the table I was mentioning. This table very clearly says, like in case of a public company, the interested chairperson directors, uh, cannot be interested person or director cannot be participate. Interested chairperson and director cannot participate, cannot vote, and cannot be formed the quorum. Only his presence can count. He can be present during the discussion. Neither his presence will be counted for the quorum, nor he can participate or nor he can vote. Same with the related party, but in the related party, he need to quit the meeting. In case of he can quit the meeting and he can join again. In case of a physical, he can go out of the boardroom and he can join after the discussion. Whereas in case of a private company, as I mentioned earlier, that after disclosure of interest, this line is mentioned after disclosing. Though you have given a general disclosure at the starting of the financial year or at the time of the change in your interest, but again at during the meeting you need to disclose I am interested in this particular item, and then you can be counted for the quorum, participate, vote, and your presence will be counted, but not for related party transaction. It could be for any item other than related party transaction, which are not mentioned in 188. Next.
Ma'am, excuse me.
Yeah.
Ma'am, can you?
Yes.
So, ma'am, how we are trying to understand that which subject matter is interest party or a related party transaction with chairman or a director, any specific director who analyze that?
Okay. For an example, like I'm on the board of the company and I'll be getting a consultancy. Though I'm getting a sitting, I'll be getting a monthly consultancy. So I'll be interested. That is not a related party transaction, because for related party transaction, if you'll check section 188, it specifically provide the sale and purchase of goods and services, like company into a business of air conditioner.
Mhm.
So there is good air conditioner. So sale and purchase, if you are doing a transaction with some other, so that will be other vendor with regard to purchase of air conditioner. That is a related party transaction. Or you are doing a lease transaction on behalf of the company, covered in the section 188. So five items which are covered under section 188. Beyond that, all other items could be which are of temporary nature, one-time nature, interest rate transaction.
Okay.
Especially in case of Diwali, you some of any of the director's wife is into a dry fruit business.
Right.
Okay, so company is buying those dry fruits for the Diwali distribution. So that is not a related party transaction, because company's nature of business is air conditioner. Company is selling the air conditioner and providing the air conditioner services, but it is buying the dry fruits for distribution to Diwali. But because wife of a director, so here director is interested, or the company is buying from the partnership firm where director is also a partner.
Yes, ma'am, I got that.
Okay.
In terms of the illustration, now I'm saying that now we have identified that okay, some transaction is related party transaction, or one chairman is the interested party in that particular transaction. So
Hmm.
we put it in that particular column, and then we ask him not to attend that particular meeting, right? So this is being done by company secretary.
Yes, interest in case of item where the director is interested. In case of a public company, he could only present there, but he'll be quiet. He neither participate, as you see from the first row. There
Right,
are three crosses and one tick mark. So
right.
he can be present, but he rest other thing he'll not be counted. Whereas in case of a private company, because private companies are normally small, closely held companies, so
Hmm.
this leverage has been provided to private companies through an amendment where they could participate and vote and counted for quorum and etc. only after disclosure. Like I am an interested party, I'll say I am interested because this I am the partner in that particular firm where you are buying the dry fruit. So I am keeping myself after the disclosure. This discussion can happen if it's a private company. If it's a public, I'm director in a public company. I'll disclose that I'm the interested person. I'll be present, but I'll not be participating.
Yeah. Okay, ma'am. Thank you.
Next, please. Passing of resolution by circulation, because in case of emergency item where you cannot meeting on a shorter span, this there is leverage, there is a liberty to pass the resolution through circulation. It has its own provision to be complied. If I'll read one section 175 of the Act provide for passing of resolution circulation, all items are covered except few items. These items cannot be passed through circulation. I think I don't need to read them out. You can go through. These are the general items. These are the specific items. And can you please change the slide? And these are the corporate action which cannot be done through passing the resolution through circulation, has to be done through meeting itself. So it's a restriction. And there are some additional item list for the listed companies whose shares are listed on the stock exchange. These are the additional items which can be done through circulation. These items has to be done in the board meeting only. Next. For rest other items, you can pass the resolution through circulation. Here also there are certain provision. Can you expand this slide a little bit more, if possible? I think we have skipped that slide. Coming back to the previous slide. Okay, it's fine. What is the procedure? See, basically, 7 days is the maximum time you can provide in case you are sending. There is a procedural requirement that draft resolution to be given. There's no need of notice because you are not calling the meeting. Draft resolution to be given along with the supporting document, all relevant information to be provided. It should also be serial number as board meetings to be serial number. Resolution by circulation should also be in a serial number. Then in that situation, maximum period can be given for 7 days. Then there is a criteria of in case 1/3 of the directors of the company want this matter to be discussed in the meeting rather than being passed through the circulation, they can request, they can ask for situation that particular resolution cannot be passed through circulation. Whereas in case more than 2/3 director, because 1/3 have a power, but already more than 2/3 have given their approval consent, whatever. So that means 1/3, there is of 1/3 who can deny this meeting to this resolution to be passed through circulation. In that situation, it counts as approved. If you want me to explain further that which is the date to be counted for the passed on, should I go detail? I think that will be very technical thing to discuss. If anybody wants, I can discuss later on. All what is the date we take for the pass in case of resolution through circulation? They shall signify their assent or dissent. They can give their assent or dissent. Things are being done through electronic mode now. Though we receive the mail that this is the resolution to be passed on through circulation, you can give your assent or dissent. Instead of signing, you can only reply back through mail. And approval of majority of the directors is not received by the last date, the resolution shall be considered not passed. In case the majority approval is not given, then it will be not passed. And in case more than 1/3 people matter to be discussed in the board meeting, then again that resolution get cancelled and it will be discussed in the upcoming board meeting. It is to be noted the meeting of the board committee records. Again, this record to be maintained, you need to maintain who has in the next. This is a resolution passed through circulation. So it is to be noted in the next board meeting which is being conducted that these resolution passed through circulation in the board. These were the resolution passed through circulation where these directors have assented and these director has dissented to the resolution. You need to take note of. And in case the meeting resolution got cancelled because it has not received the majority approval, then also for the governance, it is advisable to mention that this resolution was put forward through circulation, but due to lack of majority approval, this was not passed. So that company has a record that this was being done previously, and always fall back on the previous records. Next, please. Authority, directors, even the industry director can ask the resolution to be passed through circulation. And as I mentioned, rule number of director require the resolution to be decided in the meeting, then in the meeting. Approval, it should be approved by two-third majority of directors. Number of resolution, every resolution should be serially numbered. And the effectiveness. Briefly, I've mentioned it shall be deemed to have been passed on the earlier of any of the days. One is last day specified in signing in case approved by majority director on the last day, or date on which from required majority. Required majority is majority, more than 50%. Provided who have not yet responded shall not be one third or more than one third. So out of 7 members, 4 has already approved, so it'll be counted as approved because the remaining 2 is not. 5 has approved is counted as approved because one third of 7 is 3. So less than 2, less than 3 has already replied in 3 days, so it will be counted as a day itself. Next, please. Minutes, the most important from a legal point of view. Minutes, have writing down, noting, having a resolution, because I have seen in cases the resolution passed in the meeting, the resolution passed by the board, they just put in the minute book sufficient thing. And there has been adjudication also by the departments where discrepancy in maintaining the minutes have also cost a lot to the company. So I'll read out these points. These are very brief points, but very relevant points with regard to minutes. The distinctive book should be maintained. Like if for the board meeting, it has minute book. For the general meeting, annual general meeting and extraordinary general meeting is the one thing. For general meeting, you can have a different committee meeting, like for audit committee meeting, remuneration committee, minute books. All the pages to be consecutively numbered. And in case the company is not following this procedure earlier, so 1st of July 2015, from when the this has got effective, has to maintain the minutes with the number from 1st July 2015. In the registered office and such other place at the board meeting. It is to be maintained at registered office, but if board decide, can be maintained at any other place, as you were asking, corporate office or head office. Should be recorded that it enable any reader to within 15 days, draft shall be circulated to all the directors. Draft of the minutes should be sent to all the directors within 15 days. This is compulsory. If you are not following, you are not complying with the minutes properly. And this proof of draft being circulated should also be maintained for 3 years. The director shall provide 7 days to communicate in case, and after receiving the draft minutes, director will be having 7 days to respond back in case he or she wants any kind of a change in the minutes or some extra things to be added, or point of discussion which were missed by in the minutes. He can always ask to be incorporated in those minutes. Entry in the book shall be made within 30 days. The minutes should be recorded in the minutes book within 30 days from the date of the meeting. It should be recorded and enable any reader to understand it transpired by the meeting. Whatever happens in the meeting, whatever the relevant part should be mentioned, so that it gives an idea to the reader that he is attending the meeting itself. Whatever discussion happened, whatever point being raised by the directors, how the management answer to those, everything should be mentioned other than the resolution. Written in a simple language, should contain the brief synopsis of the discussion. The minute should be written in third person and past tense. Resolution can be written in present tense. Then minutes of the previous meeting may be, who will sign the minute? either the chairperson of that meeting can sign after being recorded in the minute book, he can sign anytime, or it could be signed by the chairperson of the next meeting when we take note of the previous minutes. And then how to sign, all the pages to be initialed and the last page of the minute to be by the chairperson of the meeting or by the chairperson of the next board meeting where we are taking note of, and he should mention the date and the place where he is signing. Next.
Ma'am, I have a question.
You have to be a little louder. I cannot
Am I
hear.
audible now?
Yeah, bit. Your voice is a little slow. Please.
Okay. So, ma'am, is there any requirement of letting the objections taken by the directors to be recorded in the minutes of the meeting? Is it mandatory or not as per?
As I mentioned earlier, when I was mentioning the authority of the chairperson, so final call is of the chairperson only. And if he consider that suggestion given by the director are not the relevant part, or otherwise it will be defamatory, or it'll have some legal implications. So the final call is of chairperson. And in case of the conflict on this particular point, then this matter, like then it'll take a legal scenario only, because final call is of chairperson. Director will only suggest the his objections or his observations or his amendments, but final call is of the chairperson only.
Okay, ma'am, understood. Also, if the objections are not mentioned in the minutes, if the chairperson calls that the objections must not be mentioned in the minute, whether the statement that one of the directors has made an objection, whether that should be mentioned or not.
It should not. It is not required by the law, by the secretarial standard, but as a good governance, definitely you can mention.
Okay, okay.
But otherwise it is not required. But because mostly these kind of communication are through mail, so if in case director has given his observations on it, so he has a record that I've conveyed this, communicated this to the company, and they have not included. In case in future there'll be any kind of a litigation, he could have a record because it'll be in the on the mail or through any other source.
Okay.
Right. Next, please. This point, chairperson's discussion. The chairperson has responsibility to ensure the minute contain a fair and accurate summary of the proceeding, and he has an absolute discretion to exclude from the minute matter which in his opinion are defamatory, irrelevant, immaterial, which are detrimental to the interest of the company. So final call is of chairman. Preservation. The minutes are to be maintained permanently. Whereas, okay, we are talking about the draft. Proof of sending of draft minutes and its delivery shall be maintained for a period decided by the board, which shall not be less than 3 years. So board can decide to maintain it for a longer period, but minimum time period frame provided by the secretarial standard is 3 years of time. Record which is the proof of sending of the draft minutes. To whom should the draft minute be sent? Draft minute to be sent particular person who are appointed as minutes to be sent to all the directors, whether they have attended the meeting, whether they have not attended the meeting. In case of a new director, because his appointment was made in that particular meeting, and he will be he'll stand liable for whatever actions been taken in that meeting. So he will be eligible for that particular meeting in which his appointment being done. And in case of a cessation of director, he is eligible to get the minutes of the meeting he attended before his cessation. Like after the board meeting, he resigned 2 days after the board meeting, but then again he'll be eligible to get the draft minutes and the copy of the signed minutes. Next. Inspection and extracts of the minute. Who can inspect the minutes? Very important. Director can inspect the minute, as I mentioned earlier also, because for his, in case of a new director, if we want to understand the working of the company, earlier this authority was not with the director, but now as per the secretarial standard, director can inspect the minutes of the previous, for the period which is previous to his appointment to understand the working of the company and the past history of the company. And by virtue of articles, any of the person may also be permitted to inspect. Articles can provide the director appointed is entitled to inspect minutes held before the period I already mentioned. The director is entitled to inspect the minutes of the meeting held during the period of his directorship, even after he ceased to be a director. Once he ceased to be a director, if he was a director for the period of 2 years from 1st of January 2015 to 31st of March 2017, he has always been lifelong, he'll be entitled to the minutes of the meeting for that particular period for which he was the director of the company. Other than the director, the practicing company secretary and the statutory auditor, secretarial auditor, department, ROC, regional director, all are eligible to inspect the minutes. Then member of company is not entitled to inspect the minutes of the board meeting until and unless articles provide. Then copy of the board resolution will be certified. As I mentioned, who will certify the copy of board resolution? Who can sign? The KMPs can sign, chairperson of the meeting can sign, chairperson of the company can sign, director can sign, or any officer or employee of the company who's been particularly authorized on that behalf can sign. Next. General content. What all to be recorded, because I'm emphasizing on this also because I came
Ma'am,
across an
excuse me.
adjudication matter. Sorry.
Ma'am, excuse me. Ma'am, can we go on last slide?
Yeah, last slide, please.
Ma'am, I'm not able to understand how a board resolution may be certified even if it is authorized. Well, any of the employee of the company can be authorized to certify a board resolution. Am I reading it correctly?
Yeah, absolutely. You are reading it correct. Though when we give the certified copy, practically I'm telling you, nobody will accept that certified copy of resolution signed by other than the director or KP, to be very honest. But
Yeah,
provision provides so, because if you give a certified copy to a bank, they will never accept it. Even you provide to a department, they might not accept it. But the secretarial standard allows the board to authorize some particular, like there are two directors only and both are traveling for a business purpose.
right,
So in that situation they authorize the one of the employee of the company to sign the resolution in case required on the behalf of the board. So this is allowed, but practically nobody accept,
right.
because in that
So,
situation you need to provide the copy of the resolution where the board has authorized this particular person to sign to certify the resolution, which resolution itself to be signed by the complete board members, all the board members. In that situation it might work, but not otherwise.
yeah,
Like
because too much of a flexibility, maybe undue advantage or miss.
that is why I'm saying, because then it'll be difficult. That is why practically nobody accept the certified copy signed by any of the employee of the company. It is
Yeah,
always
thank
by the board, but there are situations where both the directors are traveling. They give authority, they give a power of attorney, so he can attach the power of attorney. He can give authority letter signed by all the directors, and then attaching the copy of certified copy of board resolution of any of the previous records. It can be done, and it is valid document.
Okay, thank you.
I'm mentioning, though you might find this that not so relevant, but I'm mentioning here because I've recently come across that adjudicating officer has passed an order which has cost to the company a lot for not maintaining the register in a particular format provided by the secretarial standard, which require the name of the company to be mentioned, type of the company, serial number, date, time, venue of the meeting, time of commencement of the meeting, time of conclusion of the meeting is also required, all the relevant records, and then minutes should be recorded. Record the name of the following. As I mentioned earlier, directors present in the meeting through physical mode, through electronic mode, then company secretary as an attendee, and then invitees who all invitees were there. Even KMPs are counted as invitees. and the name of the director who took the chair. Everything need to be mentioned. This note is important. Meeting held at a shorter notice. And if such independent director or minority director abstain from rectifying, does not, I think we have already covered this.
So, ma'am, can you
Sorry,
shed
no, yeah, sorry.
can you shed some light on the matter where this thing has been asked and why it has been asked?
Which thing?
You're
This
saying,
adjudicating
yeah,
which I'm
yeah,
mentioning to.
yeah.
Uh, there was some case by Karnataka ROC, I think. I don't remember the name of the case. I came across because some senior were mentioning. So there's some case Karnataka ROC called for the minutes of the company to prove their validity of certain point. And when they showed the minute book, there was nothing mentioned, no synopsis of the meeting were mentioned, only the minutes of the board meeting, no serial number was mentioned, no start time of the meeting, no conclusion time of the meeting. All the things were not mentioned. It was not in a proper form. So he put a penalty.
Okay, so just a procedural fallacy they are trying to
Yes, yes.
rectify.
Like in
Okay,
case in as if you are aware, many a times ROC send any kind of a notice or RD send any kind of a notice to registered office, and it comes back saying that there's no office there. Without a wait,
right.
without a fall, they give a
Mhm.
notice under Section 12 that the company is not maintaining a registered office. So, though the notice was with regard to something else, but because the letter has come back, so the same way matter was something else. The department called for the minute to understand the some other matter, internal matter, but they could see that minutes are not being maintained in a proper way. So they imposed a penalty for not maintaining the minutes in a given secretarial standards.
Right. Thank you, ma'am.
Okay. Next, please. Preservation of minutes, it's a permanent, it shall be preserved permanently. Even in case of merger amalgamation, the minutes of the merged company, amalgamated company need to be maintained lifelong. And office copy of notice, agenda, notes, etc. These should be maintained for a period of, I think, shall be preserved in a good condition and remain for the 8 financial years. No, copy of notice, copy of agenda, notes on agenda, everything to be maintained for 8 years. Whereas, as we understood earlier, the draft minutes, supplementary notes given on the agenda will be maintained for 3 years. It shall be in the custody, the minute should always be in the custody of company secretary. And if there is no company secretary, the board can authorize any other director to safeguard the custody of minutes book. Any record destroyed after, even if you want to destroy, like after 8 years, if you want to destroy the notice, agenda and all record, you need the approval of the board. So even if the record is with regard to previous period, like for 1990 you are destroying the record, but you are destroying in a current time, it is after 1st of July, then it requires the approval of the board, and then only you can destroy. Next. This is the final slide, I suppose, or there'll be just one more slide. Disclosure. You need to mention in the board report that you are maintain the company has an adequate system to maintain this, to follow the secretarial standards, and guidance note is giving the enhanced picture only. Next, please. These are the penalties 118, which is 11, which is particularly about the secretarial standard. If you are not following, 25,000. So, in case of monetary terms, if you'll see, the monetary penalty is not very high, but repercussions are high because it can invalidate the meeting, invalidate the appointment of the director, it can invalidate the resolution passed. So repercussion in case of a litigation, it has a, even in IBC now they are following, in case they are following the secretarial standard procedure. If the record is not as per the secretarial standard, they are not taking it as a proof. So from a legal point of view, it has a very high implication as compared to the monetary penalties. Next, please. Thank you so much. I just hope